Well, thank you, Charles, and welcome to the Abuja Center. My name is Mwaboze Njoko. Now, political parties as organs for the recruitment of political leadership and governance operators, when they become unhealthy, they undermine both democracy and stability of the polity. They also give a clue to the governance vision of emerging governments and, of course, how the national development will progress. Now, when these parties become unhealthy, the entire national framework, the entire governance framework is threatened. Nigeria's main opposition party, the People's Democratic Party, is unhealthy. How comfortable can our polity be? And how does PDP's ill health threaten the stability of the country and its democracy? This is the issue in focus from Abuja Center this morning. Now, before I introduce my guest this morning, let us set the stage.
Many Nigerians, except those in the business of political long knives, stabbing in all directions, are confused on what are the legal issues, the number of court cases, and the effect of the many court rulings on the main opposition party, the People's Democratic Party, PDP. One thing, however, is indisputable. The political health of PDP is in danger. Its capacity to gather strength and launch a major contest for power in 2027 is becoming doubtful. For incurable optimists, I don't understand how these things work, they say. Overnight, PDP can reinvent itself, spring a surprise, regain its appeal, and claim Nigeria's highest political prize, power, at the center. But before that happens, this Monday, a major hearing opens at the Supreme Court to resolve what looks like the many legal and justice contradictions on the many PDP court cases coming from our different courts. The first is by the principle of rotation, enshrined in the PDP constitution. The North Central Zone should be holding the position of the national chairman of the party. That principle was the basis on which Iyorchia Ayu from Benue State became the national chairman of the party on October the 31st, 2021. When elections were on the horizon and Iyorchia Ayu was said to be close to Atiku Abubakar, one of the contestants, interest groups led by former governor of Rivers State, Nyesom Wike, protested the emergence of Iyorchia Ayu and raised all myriad of accusations against him and effectively got him out of office. Umar Damagu from Northeast, who was then deputy national chairman of the party, stepped in as acting national chairman. In other words, the North Central Zone was shortchanged. It has not served out the tenure due to it, according to the constitution of the PDP. And if this is as simple as it looks, why has it become contentious, needing the intervention of the judiciary? Now, the second issue also flows from the constitution of the PDP. Senator Samuel Anyanwu is the national secretary of PDP, or should I really say, was national secretary of the party. By the constitution of PDP, when an officer of the party prefers to go for another elective office, for example, national or state legislature, president, vice president, or governor or deputy governor, local government councillor or chairman, that officer relinquishes his position in the party. But Samuel Anyanwu, who chose to vie for the governorship of Imo State in the 2023 elections, secured the governorship ticket and still held on to the position of national secretary. When he lost an election, he simply walked back to Wadata House, attempted to pull the chair of the national secretary. It was naturally, and according to the constitution of the PDP, no longer vacant. The Southeast, by the rotation principle of the PDP, had nominated former national youth leader of the party from the zone, Sunday Ude Okoye, as the national secretary. Again, if the issue is as simple as this, and people are playing by the rules, should this be contentious to warrant the intervention of the courts? These cases have gone all the way from the lower courts to the appeal court, and this Monday, January the 27th, 2025, the Supreme Court is being involved to resolve what, to the unpracticed hand, should be a simple matter. To add to the confusion, who will represent the PDP in the case today? Acting National Chairman Omar Damagu, who is alleged to be Jacob Wike with the hand of Esau Damagu in the whole confusion, has hired J.Y. Musa, Senior Advocate of Nigeria, to represent PDP. He said that the decision to that effect was authorized by the National Working Committee of the party. However, 11 members of the Working National Committee of PDP on January the 21st wrote a letter to the Registrar of the Supreme Court and the President of the Court of Appeal, stating that the National Working Committee never authorized Damagu to appoint an external lawyer to represent the PDP. They stated that by the provisions of the constitution of the party, only the national legal advisor has such powers. Again, if that is the rule, why should this become contentious? As the courts get involved, the courts get sucked in. The Enugu Division of the Court of Appeal has affirmed Sunday Ude Okoye as the National Secretary of the party. And the Abuja Division of the same Court of Appeal says Samuel Anyanwu remains National Secretary. Is the PDP crisis a case of PDP versus PDP, or the courts versus the courts?
Well, is it a case of PDP versus PDP, or the courts versus the courts? Now, this morning, we were to have two guests, the National Publicity Secretary of PDP, to react to these developments and maybe educate us better on the goings on in his party. But he said that he would appear tomorrow because he wouldn't be able to meet our time for today. So tomorrow, we will have him in our studios. But this morning, we have as our guest Ocholi Okutekpa, Managing Partner of Numa and Law. Ocholi?
Thank you, sir.
Long time.
It's been a while.
How is it?
Very fine.
Great, great. Now, you followed our prologue.
Yes.
And you know that PDP is not alone in this intra-party crisis.
Yes.
Now, these parties, all of them have constitutions. In other words, there are rules that ought to regulate their activities.
Exactly.
Yet each of them is embroiled in intra-party crisis.
They don't just...
Is it laughable really, or are you worried by it?
Well, I'm worried about it, but not just for them. I'm worried about it for Nigeria. Because you see, the constitution of every political party is also registered with INEC. So the constitution is as powerful as the powers of INEC itself. So it's a regulation that is regulated. And that's why parties are bound by that constitution, not just because they gave themselves the constitution, but the registration, management of the party itself is something that INEC oversees. So the constitution itself has a flavor to it that is beyond that party. So it's not just laughable at the party level, it is laughable at a national level, because you are dealing with a constitution that has regulator like INEC, all right, and the constitution, because INEC derives its power from the constitution, and this constitution finds its validity in the registration process and the management of INEC. So you see, it is laughable on all fronts. It's what our politics has become, and I mean, there's nothing interesting about it.
You just mentioned INEC.
Yes.
You said the constitutions of the parties are in fact registered with INEC. And by the law establishing INEC, INEC regulates the parties. Mm-hmm. When these intra-party wranglings come up, doesn't INEC have the legal position, authority, to weigh in and say, look, this is not what your constitution says, instead of allowing it to progress and require the intervention of the judiciary?
Well, unfortunately, INEC cannot run the party for the party. So what should happen is, the reason court cases are, brewing everywhere is based on the right that derives from that constitution. It is a party member or the aggrieved member of the party who can approach the courts. Because if you toe the line you just mentioned, INEC would lose its independence. Then if INEC takes certain steps, it will appear like they are being used by maybe the ruling party, which in this case, PDP is the opposition party in Nigeria today. So you see, there are steps that INEC can take without the court stepping in certain ways. For instance, the power to deregister political parties for certain reasons as spelled out in the law, INEC can deregister simpliciter. So that if you are now aggrieved with that conduct of INEC or that action by INEC, you can go to court. But in some of the crises, you are dealing with issues relating to who is chairman, who holds this position, and all of that. INEC plays a role. And for example, during party primaries, you must inform INEC. In fact, the law regulates as to how many days notice you give to INEC, because INEC has to monitor and observe those elections and see that our politics flows in the right stream all through, from the primary and all of that. You see, but when it comes to the grievance from those processes, you see, if INEC gives a go-ahead, then INEC can even be a party, or documents from INEC, like, yes, we observed this election, yeah, we gave approval and all of that, can even be put in evidence. So at that point, that's not an INEC issue. So it's a very complex web. There is what INEC can do, there is where INEC can stop, there is what an aggrieved party can do. So you see these court cases because people are aggrieved and want to exercise their right, all right, to take out action where they believe they have a cause of action.
Actually, look at PDP.
Yes.
As of this morning.
Yes.
PDP is bleeding profusely from several stabs and injuries, all because of wranglings and intra-party interests.
But they are still alive. The bleeding has not killed them.
Let us maybe until you get into the throes of death, then we start express concern. Now, all manner of frivolous. Pardon I'm not an authority to determine whether an issue is frivolous or not. But looking at the party's constitution, things that to me, an ordinary person, appear simple, get as briefs to lawyers to say, look, take this matter to court on my behalf and all that.
First of all,
just a minute. You're a lawyer. Is there no limit to the brief a lawyer can accept, even after looking at that brief and knowing that it's totally frivolous?
Well, let us start from your conclusion. Your conclusion may be completely flawed.
I agree.
Because what you see in the news may just be another person's summary of the real issue. You see, a lawyer can exercise, his professional discretion to accept or reject a brief. But you see, when cases are reported in the public space, there is a likelihood. I have been in cases that when I read the report, I wonder if we're talking about the same case. So the likelihood is the issues are watered down. So your opinion is expressed from outside of the facts
Of the law.
the lawyer may have, considered to take the brief. Then on a lighter note, country is hard. People need to eat. So if PDP wants to fight, lawyers will make money. I mean, in the prologue that was, playing earlier, you will see that the focus on the Supreme Court, you had so many lawyers. You had senior advocates, you had other lawyers. I mean, this is how the economy of the practice of law runs when it comes to litigation. So what you may term frivolous may just be the prayer answered for a lawyer somewhere. So it is not as frivolous as you feel. If you have a course of action, and I can review the course of action and reason with you why you have a right, and you are ready to pay, then, the equation is complete. You have a right, you have a course of action, you have the money to pay, I have the experience to represent you, and I have formed the opinion that this course of action has a likelihood of success. The fact that it fails does not mean that it is frivolous. Even if the court comes to the conclusion that the matter is frivolous, that is the conclusion of the court. It doesn't mean, and that is why we have the privilege to travel through the courts. Because the fact that a high court or a federal high court comes to a conclusion that is frivolous does not mean it's the end. There's still the Court of Appeal. There's still the Supreme Court. So until we hear that at the Supreme Court, and let me quickly also say this because the Supreme Court says it too. The Supreme Court is not infallible. All right? They are only infallible because they are final. If there was a court to determine the matters after them, we will realize that the Supreme Court can also make a flawed decision. But I cannot say that as a lawyer because they are final. So their infallibility is rooted in the fact that they are the final court. So you see, when you take it from that perspective, one person's opinion that the matter is frivolous may not necessarily hold water when you regard the fact that the lawyer considered before he took the brief. And on a lighter note, again, money, economy.
If you have it, go the whole hog. Ocholi, let me draw attention to a specific case in the PDP.
Yes.
And that is that of the National Secretary of the party. That case has gone to 3 courts. In fact, 3 high courts, has reached the appeal court twice. And it's not the issues coming up today at the Supreme Court.
Yes.
The same matter is taken up in a court in Owerri. The same matter is taken up in a court in Kano. The same matter is taken up in a court in Abuja at the same high court level before it goes to the appeal. This tendency for interests to shop for judgment over the same matter, how can the courts stop it?
Well, unfortunately, this is now coming into the question of the integrity of the judiciary. And you see, a nation will enjoy the politics of the politicians it elects. And a nation will suffer or enjoy the quality of the judiciary it appoints. This is not a difficult matter to answer, but it has become a Nigerian situation. Because my assumption is, I'm not in any of the cases, so I can even speak freely. My assumption is a lawyer that knows what he is doing will raise an objection in the latter courts or the subsequent courts where these matters are taken to say that there is a matter pending with the same cause of action, same parties in so and so court. Because what politicians have done sometimes is to reduce the judiciary to his houseboy or errand boy, where they are able to push the judiciary around until they get what they want. Now, I would not hold brief for the NJC. The NJC has done as much as it can do with discipline, all right, and more should come. In fact, I advocate for more to happen. Because the truth is, if you practice in Nigeria, there are courts you will go to, and it leaves a lot to be desired. All right. So if a party or politicians are forum shopping, it is important for the judiciary in protecting its own integrity, all right, to act. And we are all part of the judiciary, whether from the bar or the bench. So speaking as a lawyer, I expect that the lawyers involved owe the court a duty, because we are dealing with a system that is not necessarily as digitized as it should be, where a judge can sit down and click into the matters and, be able to know that so and so matter is pending in another jurisdiction. But the court has a duty, even if none of the parties raises this issue that similar action, similar parties pending somewhere. The court has the duty to take judicial notice, because these judges live in society. They also follow the news. They also know what's going on. And that's why judges who are intelligent and know their job, even if no party is raising it, will turn to them and ask, I am aware, or I take judicial notice of the pendency of so and so matter. Can you address me on it? So when you look at it both ways, whether from the bar or from the bench, we owe the judiciary a duty, because our name is already spoiled. In fact, the honest truth is, if you want to convert this entire conversation to the judiciary, we will not stop talking till tomorrow. The issues are enormous, the issues are deep. So it now behoves on the judiciary to take steps to preserve its integrity, or to redeem a name that is dying, because the name is going. Because now it is a very dangerous thing in this country to introduce yourself in certain circles as a lawyer. The assumptions about you are not funny. So it's important to see that not from the political perspective, because you see, clients will always be clients. In my years of practice, clients will suggest to you things you should shut down. So clients will be clients, because this person's interest is an outcome, whereas my interest should be, all right, the integrity of the ethics of the profession to which I took oath. So until we understand it from that perspective, politicians are going to drive us to do things that we're not proud of and that will make us look like politicians. I am not a politician. I don't carry the card of any party. So I should be able to, tell a politician, I can't go this way.
Actually, in the course of this submission, you've mentioned infrastructure. You mentioned that a judge should take judicial notice of a matter, a development on a matter, even if the lawyer did not raise it. That, I just want to digress a little bit.
Yes.
The Nigerian judiciary, to me, seems to be grossly inadequate when it comes to infrastructure. I see judges whose fingers are bent writing. They are perpetually looking this way because they are perpetually writing. And they want to cite 2, 3, 4, 5 precedences, and they have to go through and go through manually. Is our judiciary under-provisioned? Is our judiciary and its development neglected? Do they lack infrastructure? In administering justice?
I think in the 21st century, we are grossly behind when it comes to infrastructure. You see, we don't even need to talk about digitization or some levels of sophistication. You go to certain courts, you're actually ashamed to be a lawyer. You're ashamed. We still sit on benches in a lot of places. We still sit in buildings that are being held by the grace of God and its pillars in the name of going to court. I mean, you see, if you practice in Abuja like I do, or out of Abuja because we go to other jurisdiction, you may not necessarily experience a lot of what we're saying. You see, but you still experience it. Within the FCT, you still, I mean, how many times have we been in court and there's no light? Yes, and the judge and counsel are all sweating. And yes. In fact, I was in a court and the judge had to send to the registrar to find out from the administrative office what's going on. And they said the gen was down and that they have been working on it. So the entire complex was without light. And we're conducting proceedings. So let's assume he is digitized and has a computer in front of him.
of the
How is he
power.
going to operate the computer in front of him? In fact, air conditioners in most of our courts are like artifacts, like pieces of decoration on the wall. So where do you start from? And how much is the judicial officer earning? So should the judicial officer buy a generator for the court? So when you look into these things, you are dealing beyond. You see, saying digital is going far. So yeah, if you appear in the Court of Appeal in the Supreme Court, yes, you can see some facelift, what should appear like what is the standard. All right, the microphones working and all of that. But you see, how many courts enjoy such privilege? And these are the appellate courts. This is not where the main battle happens. This is where appeals are determined when the battle is over. At this point, the real fight has been fought. So you see, by the time, don't even go to the lower court like the magistrate court. You will just weep. Then don't even leave the FCT and go to the states, where I practiced in some states before I ended up here. It is a sorry tale. So when you look at it, the conditions are not good enough. Like when you talked about writing, our judges are still writing longhand. That is still the mode of operation. So you see, when a judge has 15 cases in a day and has to take note longhand, let me put perspective to this. I have done matters that I cross-examined 3 hours. That's one case.
And the
judge has to take note of every proceeding. So by the time you pick your record of appeal, or record of proceedings rather, and the judge does not capture some of the proceedings, he's human. If you are writing for 3 hours on one case, or 2 hours on one case, or 1 hour on one case, chances are that you will form an opinion that thing that man just said is not necessary. Whereas it is necessary for his case. So you pick the record of proceedings sometimes when you apply for
that
it,
is missing.
And you are wondering, what do I really have inside of this? But of course, the picture you always have out there is pictures like this, where you have fantastic, array of judges, the proper courtroom. No, we have a problem. We have a problem. Whoever needs to look into the matter needs to look into the matter that the judiciary looks like an impoverished, forgotten, and rejected, dejected piece of the unit of this country. So it's important that that arm of government, that we look into it in all the cadres of the court, so that we don't practice like we are still in 1940 when we're in 2025.
Now, actually, just let us put a cap on that one. Can such a demeaned arm of government, such abused arm of government, don't it have angry or unhappy operatives, and will such angry operatives give justice?
You are being modest. It's not about being angry operative. It is that when your condition is so weak, anybody can offer you stuff and it will appeal to you.
I didn't hear you.
Yes.
Let us go to the next opportunity.
You appear to be a judicial officer.
I want to look at the courts.
Yes.
Please educate me here. The state high courts, the federal high courts, is the state high court one court? Is the federal high court one court? And is the appeal court one court? Just educate me.
Very good question. We have what we call courts of concurrent jurisdiction. That means they are one court just sitting in different places because their jurisdiction is one. So when you come to the state high court, for the sake of geography and access to justice, you have the same court spread across the state. Like when I was practicing in Benue State, you had the High Court of Benue State. So you don't have High Court of Boko. Boko is a local government, or of Otukpo. No. That is the High Court of Benue State sitting at that location. So for all intents and purposes, and to look at the legal implication, the High Court of Benue State sitting in Boko is the same court sitting in Otukpo, just manned by a different judge. So the judex is a different person, but the office is the same office. And the same thing happens for the bigger cities. Like if you're in Makurdi town, you had the CJ, that's the chief judge of the state, sitting. You have other judges within Makurdi, because more matters are happening there and all of that, sitting. They are all a concurrent jurisdiction. All right? So even though you have within their ranks seniority, the seniority does not count for the jurisdiction. It just counts for the appointment, for administrative purposes and all of that, for elevation and all of that. The main deal is that this court is one. So you can't have the same matter litigated in one division of the court and another court on the same issue, same parties.
Also,
you cannot. And if you get judgment in, say, the court in Makurdi, you do not have the standing in law to go to Otukpo and say, okay, since this one,
let me get.
What the judge will tell you here is that this court, if that's the proper language, this court has decided this matter, and you refer to the name of the parties and the division in which it had been taken. Same thing with the Federal High Court. The Federal High Court is one court. Whether it sits in Owerri, or it sits in Makurdi, or it sits in Kanu, or it sits in Lagos, is one court. All right? For the Federal High Court, what you have is geographic location, all right, or jurisdiction, geographical jurisdiction. So that if a matter emanates, for example, from PDP River State, and there is a Federal High Court located there, why are you jumping to Lagos? So although it is one court, geographic location or geographical location is so that you can litigate matters easily and in the court that sits around or in that jurisdiction.
But let me just put in here.
Yes.
Why is it then that a matter comes up in a Federal High Court, for instance, in Owerri? The same matter resurfaces in a Federal High Court in Abuja.
Abuja is a very interesting ground.
And the courts entertain them.
No, Abuja is a very interesting ground. And that's why a lot of that happens. Do not forget that in most of those cases, a federal agency is a party. Like INEC, police, and all of that. So, smartly, particularly when you come to forum shopping, when you have a preferred forum, as it were, where you want the matter ahead, you can use a party to clothe that particular location with jurisdiction. Sometimes you see lawyers take out certain matters in the Federal High Court because they do not want to go to the State High Court for certain matters. So you see, especially it happens more in fundamental rights proceedings, where somebody just adds one agency of government who may have played an insignificant role in the whole fact, just to close the Federal High Court sitting in a particular jurisdiction or division with jurisdiction.
Can't a judge look through that?
Of course, and the judges do very often. I can tell you that. There are matters that have in fact been transferred, like go to another jurisdiction or making another, transferring to another jurisdiction to be held in that jurisdiction. You see, so the truth is, it is not what we are proud to admit, is that lawyers will also use any tactic, of course, governed by ethics. But a lawyer's ethical consideration from another lawyer's ethical consideration will not be the same. So a lawyer may defend that they have weighed this matter through their ethical lenses and may still be doing what they should not be doing. So lawyers forum shop. Because at the end of the day, the pressure that your clients bring to you, you want to, get results. So I can't defend what every lawyer would do just because they want to aim at a certain result and what another lawyer would not do. So in most of those cases, like I said earlier, it is for the parties involved or the parties whose interest is at stake to have conversations with their lawyers and for their lawyers to advise how to challenge, this forum shopping behavior to say, look, if you look at the course of action, my lord, ABC will place this matter better in the Federal High Court sitting in so and so location and not in this jurisdiction. So these are issues that you need to approach from the perspective of the intelligence of the lawyer you pick and the integrity of the judiciary who is ready to answer. So that if a judge or a judex, as it were, is sitting or presiding over a matter, the judex should be able to exercise, the discretion to see between the lines and come to a conclusion that is not just, but that can be seen as just by an ordinary man walking the streets.
Let me just ask you. I'm still coming to the heart of this matter. Isn't there anything the Nigerian Bar Association can do in this matter? To ask these forum shoppers, these people who sew apparels to fit a case into a particular location, that they are not doing the profession any good?
NBA does its best, but there's just how much NBA can do. And without, and I say this with every sense of responsibility, no bile, I do not know any officer of the NBA at the national level now who is involved in any of these cases, so I can say what I want to say with a clear heart. What if the NBA has interest, not necessarily public interest or known interest? What
case?
If I'm an officer of the NBA at the national level and the person photoshopping is my friend, or I actually have interest, whether known or unknown? You see, the truth is, NBA has its limits. We have the Legal Practitioner Disciplinary Committee that can discipline for various reasons, like conduct unbecoming of a legal practitioner, professional misconduct. There are various grounds that NBA can, petition or accept petitions and discipline a member. See, most of the things we're referring to are not issues that can necessarily come within the purview of professional discipline. Most of what we're saying is just a matter of preference, is a matter of style of practice. And that's why the courts are there. And the courts have done a lot. So this is not an NBA thing. NBA can, NBA does its best through conferences where we improve. That's what I call it, continuous legal education. To help lawyers improve, upscale, get further training. Conferences do that. NBA has different sections, section on legal practice, section on this and section on that. NBA has those forums where, we try to improve ourselves. NBA also issues statements from time to time to see how best we can deal with the issues of regulating our conduct. But at the end of the day, the person with the biggest responsibility when it comes to this regulation is the court itself. Because that's why you have cases where the court will impose punitive, damages or even costs against lawyers. All right? I was in court a few days ago, and a party that lost, the court slammed the party 200 million in costs. You see, once we heard that, we just knew that this is punitive. Like, the court must have looked at the matter and said, for doing this, for fighting this cause, we expect you to know better. So, of course, the persons have right of appeal.
You pay for it.
Exactly. So, you see, some of these things, the judiciary has begun to respond. And we need such responses. Now, I speak as a lawyer, because the response can be on me if I do certain things. All right, so the judiciary can respond. And for the last few years, Supreme Court has really, really come heavy on lawyers on this. Because ordinarily, cost is against the party, not the lawyer. But you know what the Supreme Court has been doing now? And what the rules look like? Right now, lawyers are being, cost is being imposed on lawyers. Because there are certain things that the court comes to the opinion that you should have advised your client differently. So for bringing this matter at this time the way you have done, heavy costs.
Oh, well, this is not the core issue. We just digressed. Well, you are watching Signature Morning this Monday morning from our Abuja studios. We've been examining the crisis in the PDP. How healthy is it for Nigerian polity and governance? We take a short break and return. Please stay with us. You are welcome back. We're still here talking about the crisis in the PDP. My guest is still in the studio, Ocholi Okutepa, an Abuja-based lawyer. We are discussing, of course, crisis in the PDP. Now, Ocholi, I'm going to a specific challenge. We just talked about one court, whether it is state or federal, or whether it's appeal court. The position of the National Secretary of the PDP has become very contentious. As we get the background in the prologue, let me just recap. Senator Samuel Anyanwu was elected National Secretary of the PDP. In 2023, he decided to run as a candidate in the governorship election of that state. He ran and he lost. And he walked back to pick up his position as National Secretary of the party. By the constitution of the party, you either choose to remain as a national officer of the party or you go for an elective office. He ran for the governorship, got the ticket, and held the office of National Secretary. That is issuing contention. The Enugu division of the appeal court ruled that he was no longer the National Secretary. The person appointed while he was away on the campaign trail was now the legitimate National Secretary by virtue of the constitution of the party. That was what the appeal court in Enugu ruled. The same appeal court in Abuja ruled that he remains the National Secretary of the party. Are we not in confusion?
Well, I wish I had the privilege to read the decisions in question, but I'm even restrained to talk about it in certain ways because it's still subject.
It is.
Still before the court. What would be of interest from a legal standpoint is what course of action led to the appeal in Enugu and what course of action led to the appeal in Abuja, and what was the ground of appeal in Abuja and what was the ground of appeal in Enugu. Because the tendencies are that when you come to the media summarizes it as the same thing.
Jody, where I'm summarizing.
Exactly. So you see, I wish I have had the privilege to read the judgments in question. I may have been able to demonstrate to you that the courts are not that stupid. I know we have dealt with conflicting decisions of courts of the same jurisdiction, like the Court of Appeal. We stopped at the Federal High Court in our last intervention. The Court of Appeal is actually one court as well. It just sits for the purpose of convenience and access to justice in different divisions. All right? So when you look at it, what is of interest is the course of action that led to the appeal, the grounds of the appeal before the court. But having said that, even without reading the judgments involved, there's the Supreme Court. And that is why if you look at most political cases, you have a hydra-headed appeal, where this person appeals, this person cross-appeals, and the Supreme Court gives one decision and says that all other appeals abide by this decision. So it is not new to our jurisprudence. It's not the first time it will happen, even if it is worst case scenario, which I will say it is not. Why would I say casually that it is not? You couldn't appeal, or you cannot appeal from an appellate decision of the same court. That means the matter appealed against in Abuja must have emanated from a different proceeding. So if you participated in that proceeding that led to this appeal, it is too late in the day to come here to complain that there's a decision in Enugu and a decision in Abuja. Did you not participate? The only thing that can exonerate you is to argue that even while I participated here, I participated in protest. I had an objection to say you cannot do this when we are there. All right? Because a lot of times what happens is that this course of action, although arising from similar fact, is a different course of action. And maybe the parties are even altered. The parties may not be exactly the same. So a different course of action is going on here. And sometimes what actually happens? Party A believes that I can fight in Abuja. So he files something in Abuja. Party B realizes that, okay, let's deepen the confusion since you are ready for confusion. I take another course of action although related, and party B files here. So again, well, it's same people, maybe one or two extra parties, all right, and fighting through with different set of facts. Again, when we go back to the integrity of the judiciary and how we practice our law, these are issues that we should come to the point of no. Why are we having concurrent matters?
I was coming to that.
Yes.
Does a matter really, no matter how many people, how many interests are taking them to court or are taking it to court, myself and two others file a cause of action in respect of a matter. Some folks discover that they can lose here. They raise another set of people to file the same matter in a different court, not the same litigants. Is there no single substance to the matter? So no matter how many human beings
you are going, the problem is that you have gone backstage. You are the one that know that this set of people were raised by the same person. What the law looks at is this person who is appearing before me, does he have a cause of action? And cause of action is often rooted in the law. So if based on the PDP constitution, party A has a right to go to court, it doesn't matter who is bankrolling him or who is behind him. What the law will look at is, does he have a right, all right, that he can articulate before this court? So you see, that is where the law comes in. And unfortunately, if you look at decisions of court, this is why the court has made several pronouncements on what we call abuse of court process. So it is not new to our jurisprudence. What happens is when these cases travel, you will see various instances where the court comes to the conclusion that you have simply abused. And you see, some of the definitions of abuse of court process is like using the judiciary, which you had right to use, to the irritation of another, multiplicity of action, and all of those. So the most important thing at this point, appeals will land before the Supreme Court. The Supreme Court will look at them and in most cases consolidate them. Because this journey you travel from Enugu and the one you travel from Abuja, you should have been in the same flight. I don't know why you are in different cars. So let us consolidate and let us settle the matter once and for all. Or in some cases, we are aware that appeal number A, B, C, D are pending and they are related. So our decision here, those ones will abide by, and they don't even bother to come out and give any decision on those ones. Because I have decided that this appeal will control what happens in those ones. End of story. And again, like I said, that court is infallible because it is final. So whether you like it at that point or not.
That is final.
Exactly.
Actually, I'm not going to involve you in politics. Twice in this conversation, you said, I'm not a politician. I'm a lawyer. So I'm going to take my next issue not from political dimension, even though it involves politics.
Yes.
I had said earlier that PDP was bleeding from stabs from so many interests. Let me take the legal stabs and forget about the long nights of night meetings. When the party's constitution is virtually being shredded by too many contending interests who want to interpret the constitution of the party in ways that protect their interests, how does it affect the running of the PDP as an organization?
Well, it weakens the party because we have a very weakened opposition now. And if you look at the Nigerian political landscape, Peter Obi's voice and that of Labour Party appears to be stronger as a political opposition today. Why? A party that should be bigger, stronger, and more powerful has focused more on its internal crisis than being a proper opposition to, the governing party. And that's a problem. So it doesn't help our polity and the development of democracy if internal wranglings and inter-party affairs would dominate the lifetime of a party that should be a competent, worthy, strong opposition. So it is taking something away from the Nigerian society or Nigeria as a nation, that we do not have an opposition that can keep the ruling party on its toes when it comes to issues of critique or issues of challenging the policy of the day or giving commentary as to the direction of the nation. And ultimately, it is also technically or surreptitiously leading us to a place where, as a nation, we may actually have only one viable party contesting the next election. Because the process of being an opposition party is how you also sell your manifesto or your agenda to a people you are not yet leading, who should have the benefit before an election year comes round to know what you have said, how you have said it, and what you claim you will defend when you are there. So that when campaigns come, you are simply building on what you have done. Like every day you turn on the news, Mr. Peter Obi is making news some way or the other. I don't hold his brief, I'm just giving an example. So the PDP is not just dealing with itself wrongly, the PDP is also stealing from the Nigerian society what we deserve. And we deserve an opposition or opposition parties that will be able to keep the government of the day on its toes. So I am not surprised if the government of the day does whatever it wants to do, because there's nobody checkmating them, all right, and nobody is showing them that there will be consequences if you continue to lead us in a direction that we should not be going. So it is against the interest of the PDP, it's against the interest of the common Nigeria walking the street, and very importantly, against the interest of those who cast their vote for PDP in the last election, because you have people who believed in you, whose interest you should in fact pursue by being a viable opposition party.
Meanwhile, you are having this crisis of internal rights.
Exactly. So you are losing those people who even believed in you in the last election.
Not your own constituency, and it might be my last point of conversation. Sometimes you mention old judges, Esho, Oputa, and you talk about judicial activism. You talk about using the judiciary to put society on the right path. This kind of political rascality that seems to create confusion for the polity, and as you just said, that denies the electorate what it ought to benefit by supporting a political party. Instead of projecting what it stands for, it is projecting what is tearing it apart, and the public begins to doubt its confidence in that party. When these rascals get into the courts and creating all manner of confusion, where is the judiciary in telling them this is not in the interest of Nigerian polity? Will the judiciary be wrong in doing that?
The judiciary will not be wrong. And that's why you see the Supreme Court, for example, is not just a court of law, it's a court of policy. Because whatever the Supreme Court decides, hands down a precedent that we must all follow. So you see, if you look at the Nigerian political landscape, you may not be as happy with decisions of the Supreme Court of recent times, and may easily refer to the good old times, like you mentioned, the Eshors of this world, the Oguntades, the Oputas, and all of that. I'm not necessarily agreeing, because a lot is still coming out that is defining, the direction of legal policy, as it were, and contributing to the polity. The thing is, that power is most resident with the Supreme Court, not the judges of benches that are lower. Because whatever a judge decides at the High Court or Federal High Court level is still subject to the decision of the Court of Appeal. All right, and whatever the Court of Appeal decides is still subject to the decision of the Supreme Court.
So is the Supreme Court not seeing the red flag?
No, if you follow the judicial news, the Supreme Court is doing a lot. We may not agree a lot of times. You may have your criticism against certain decisions, but again, one of the things the Supreme Court looks at is, of course, interpreting the law and shaping the direction of the law. I'll give you an example. A very simple thing in the 2011 election cycle appeared to undermine the hearing of election cases. There's something we call pre-trial, application for pre-trial during election petition. So back in the day, when there was amendment to the Electoral Act in 2011, a subject came up. I was involved in one of those cases, how to apply for pre-trial. So a lot of cases were being thrown out because of the mode of application for pretrial. So, and there was this debate as to whether it's by a letter or by a motion. The law was not very clear on the point. It only gave the time frame for applying for pretrial. Some people even fell for it when they did not apply within the time, and the tribunal were bound to say, you know what, you did not apply for pretrial, it's a condition precedent to hearing, we cannot hear you, and an election petition being sui generis, extension of time is often not, granted in most cases. We can't extend time for this, and an entire petition gone. But this matter traveled all the way to the Supreme Court, and in Suswam's case, and it was very interesting. You see, with a wave of the hand, the Supreme Court said, even if you just met the secretary and say, I hereby apply for pretrial,
You've applied.
what have they done there? What they did at the time was to make sure that the issue of application for pretrial does not store the hearing of a matter, because that became the case. And what respondent lawyers did was to set traps. Lawyers are still doing it, even in the last election cycle. Lawyers are still trying to set every trap against the hearing of the matter. Because you see, if I can steal a match without playing the match,
You've already won.
I have won.
Well, my producer is giving me my time is up. Well, in the past 1 hour, I've been conversing with Ocholi Okutekpa. He is the managing partner of Numa and Law, and we've been discussing the crisis in the PDP, moving from the real crisis into how it's affecting the judiciary and our polity. This conversation continues tomorrow, but this time it will be with the National Publicity Secretary of PDP. For this morning, let me thank Ocholi for coming to the program.
Thank you, sir.
Well, my name is Mwabo Zenjoko. Can I just say good morning and thanks for joining us.